Court is now open. You may be seated.
Commonwealth versus Rodgers.
Ms. Sweeney? Ms. Sweeney?
May I please the court? I'm here representing Milton Rodgers on an issue of a Rule 36 motion to dismiss for failure to grant a speedy trial. This case has kind of an unusual perspective because a number of things came together to seemingly prevent the defendant from getting what he was constantly badgering the Superior Court for. That was a speedy trial. The issue that we're raising here is that the judge, the motion judge, improperly denied that Rule 36 motion by finding that the Commonwealth had justified a period of time during which the defendant had, at the beginning of which the defendant had filed a motion to dismiss his court-appointed attorney, and that motion lay dormant in the Superior Court's case file.
But counsel, do you agree that the defendant had agreed to pursue the DNA strategy?
Well, there were a couple of periods of time when that was an issue, and yes, the defendant had agreed to do that.
Which, by definition, meant there had to be continuances.
That's correct, Your Honor.
And that's what he had, I think, 3 lawyers, didn't he, at different points in time?
That's right, he did.
Each of those lawyers pursued that, and he agreed to that as an underlying strategy. So, in order to pursue the DNA, it required that there be continuances.
That's correct,
and he
Your Honor.
acquiesced in that, didn't he?
And he did, but at the end of April in 2002, he told Attorney Jordan, who was the attorney at issue there, that he did not, well, I believe it's April 28th or something around that date, he told him he did not want to pursue the DNA test and he wanted to go ahead for trial. And the lawyer said, well, I can still pursue it. And he said, well, it doesn't matter. I want to go to trial. And then when the attorney continued to agree to another continuance, that's when he filed the motion to dismiss the attorney. It is true, though.
Go ahead, finish your answer.
I do agree, though, that later on, when he got another lawyer, he agreed then to go ahead with the DNA testing. But that really doesn't resolve the issue of this period. I think it's a 4-month period in the middle of 2002, where his motion to dismiss Attorney Jordan was not heard by the court.
So in other words, your position is that for that period, which I think is June 12th of 2002 to maybe October 25th of 2002, the court should not have permitted, or certainly should not have ruled that the continuances were either agreed to or sought by the defendant, right?
That's correct, Your Honor.
But since he was represented by an attorney at that time, wouldn't the normal procedure be to have his attorney bring a motion on his behalf and bring it to the court's attention? Isn't that what our rules require?
That's correct, and that is a major issue
that
the Commonwealth raises, the issue of whether the counsel should be acting for the defendant. And of course that's the case, that a person does not have the right to go pro se and represented by counsel. The problem, though, is that the defendant had filed this motion to dismiss his attorney.
But yes, he filed a motion, but then many times these motions come in. I don't know what your client's motion looked like, but many times motions come in from unrepresented parties that are quite lengthy, that are difficult to read, sometimes illegible. Are you going to suggest that the clerk is to be required to read these motions and determine what they say, what the gist of the motion is?
In this case, yes. Because
it can't be just this case.
Well, this motion, I think, one could argue that if it were a motion that was long and, complicated and had, as many of this client's motions were. This one, though, this motion to dismiss, which is at, I think, A36 in the appendix, is a form. It's typed.
Just a form, one-page form.
It's a
Motion to
one-page
dismiss
form.
attorney.
It's a motion to dismiss his attorney. And the court, the clerk is part of the court. The court, this is not like there's the clerk and the court and this is part of the judicial system. And the clerk, yes, does have an obligation, if the clerk sees such a motion, first of all, to docket it.
I take it, and this was the first motion that was not docketed?
That's correct. This was the first motion.
Never docketed, never brought to the judge's attention?
That's correct, Your Honor. And the other problem with this is that it complicates this a little bit. It makes it more troubling, as the appeals court called it, was that, or I thought it was troubling, is that even, later on, a month or two later, I think it was a month later in mid-July, a Superior Court judge ordered that none of the defendant's motions be docketed. But there were a number of motions. This particular motion is, and I did actually, very carefully look through this file. This particular motion was put in the case file. It was never docketed. It never brought to the judge's attention. There were other motions that were not docketed and were, who knows where they were put, but later they found their way into the envelope of, that applied to the order. In other words, the order didn't exist, yet motions were being put in it. But that's not, that goes to my case, that goes to show that there really was, the clerk in this case was remiss, the court was remiss in doing this, and that just goes to my case. It's not to say that the judge doesn't have the power to do that, certainly, but this motion was very clear. If I were on the other side, I could say, well, obviously this was illiterate, the spelling was ridiculous, it was long. This one wasn't. It was very clear. The other thing that, if I may address one of the Commonwealth's points, that they say, well, the motion itself did not give as a ground the speedy trial issue. So how do we know that that's the reason? Well, I would say that in response to that issue, is that the numerous filings of the defendant immediately after that, I say filings or submissions, some weren't filed, were followed by papers at A37, A38, Supplemental Appendix 3, Supplemental Appendix 4, Supplemental 10, and 14, all of which tied the client's dissatisfaction with his attorney to the speedy trial issue. In other words, and he never raised anything else about the lawyer that he was dissatisfied with. So I think the inference is fair there that was the gripe. That was, I don't think there's any other argument that it could be on anything else. And yes, it isn't. It's kind of a strange case because all these things came together in a strange way. Why did the clerk not bring this to the attention of the judge in this case where the client was so insistent on the speedy trial? If there had been no such motion, we'd have a different case. Granted.
Is it clear on this record that this motion was served on the Commonwealth and that it was supplied to then counsel for the defense?
The answer to the second question is no, it's not clear that it was sent to counsel. In fact, to the extent one can tell from this.
But was it sent to the Commonwealth?
It was served, according to the certificate of service signed by on page A36. He said he certified it he said the attorney of record for each party by mail on June 12, 2002. So there is a certificate of service there, which should have put the Commonwealth on notice. And what we're arguing is simply not that one little piece of point justifies our conclusion. It's that all of these things coming together made it inexcusable why someone could be shuffled through the system like this without being attended to. This motion.
Can you clarify something for me now? He filed his motion to dismiss Attorney Jordan on June 12th. And this motion was not filed. It sat in an envelope someplace. But didn't, after that date, Attorney Jordan pursue the DNA testing? And didn't the defendant understand that was being pursued? And didn't you just say earlier that a defendant can't be both pro se and represented by counsel at the same time?
The last point, yes, correct. But the defendant was entitled to a hearing on that motion. And if Attorney Jordan pursued the DNA testing, he
And
was...
if the defendant acquiesced in it, that he was getting the benefit of that?
Yes. Yes, if he did acquiesce. But we would say that the motion to dismiss counsel should have been heard, and at that hearing, the judge didn't have to allow it. It was the delay in the hearing. I mean, you know, you could say, what is the error here? I mean, the Commonwealth says that he should have then filed a motion to compel the court to file the motion nunc pro tunc, like in those cases.
Well, clarify this for me. When was Attorney Jordan actually dismissed from the case?
It was, I believe, October 25th.
And how did that come about?
Attorney Jordan moved to withdraw. And he moved to withdraw, and the reason he moved to withdraw was that he got a notice from the BBO that Mr. Rodgers had filed a complaint against him. And we do not know. In fact, just looking at my brief, it said it was clear. It's unclear when he got that. The record does not demonstrate when Attorney Jordan got that BBO complaint. But in a letter to the court, or a motion dated in August, Mr. Rodgers said that he had sent a complaint to the BBO about Attorney Jordan. I don't know how these things work.
Well, can you help me understand what the judge was referring to when the judge said this? The court concludes that if the defendant truly believed in June of 2002 that Attorney Jordan was not properly representing his interests and wishes, then the defendant should have pursued his motion to dismiss Attorney Jordan, as he in fact later did with Attorney Jordan and Attorney Murray.
Well, as I say in the brief, Your Honor, it defies explanation. It's the unkindest cut, really, in the decision, because it's like, why didn't he pursue it? He pursued it to the extent that the clerk's office was obviously, saying, I mean, he wrote a follow-up letter saying he didn't see it on the docket. Then he followed up with these motions for habeas corpus, in which he mentioned he has the appendix, page 37, 38, supplemental appendix, page 4, page 10, a letter to Judge Del Vecchio, 2 letters to Judge Del Vecchio, in which he mentioned that he was dissatisfied with his attorney. Now, he did, he did write a letter saying, with respect to that particular motion, he said that motion was not, why doesn't that not appear on the docket? And that there was no response, I guess, to that letter. Now,
I am very hard-pressed to figure out what else he could have done, if that's your point.
Yes, that's my point.
I'm very hard. I don't understand the judge's ruling in this regard, because I don't know what else he could have done. He
could have asked his attorney to file a motion to withdraw.
Well, yes, I guess he could have done that, but we don't know that he did.
But he filed a motion to dismiss his attorney.
He filed a motion to dismiss his attorney. This guy really, it's almost like, the boy who cried wolf or something. I mean, no one is listening to the man, and the more he...
Not only they're not listening, they're not even filing or docketing his filings.
Right, and the more he presses on, then the less they listen to him. That one motion, I agree with all the things. He doesn't have the right to file all these motions, and, but the one thing that should have been attended to was that motion to dismiss his attorney. Now, there is something in the record, in looking over this, there's I noticed in the clerk's minutes, there is, when attorney, one of the justices asked, how did the attorney get out of it? Well, he heard from the BBO, I think it was Justice Ireland maybe, and he heard from the BBO, and so he filed a motion to withdraw. In the docket entry, the docket entries have no mention of the motion to dismiss counsel, the motion at A36 that my gripe is based on. However, the clerk's minutes have a little entry on the date that Attorney Jordan's motion to withdraw was allowed, on October 25th, saying, it just says something like, motion to dismiss counsel, and then it says motion to withdraw. So for what that's worth. I mean, that's the thing that sat there for 4 months. And then it refers back to paper number 26, which was the motion to withdraw. But
Attorney Sweeney, if you're right, I did a little bit of arithmetic on this. It was about 135 days between June 12th and October 25th, the time he filed his first motion and the time that the motion to withdraw was allowed, that should be removed from the calculus. But during that 135-day period, did the defendant get the benefit of any time that was being spent on the DNA request that he had, I assume he ratified?
That's a good question, Your Honor, but I would argue, and I don't know the answer to it, but I would argue that even if he did, I don't think that such a hypothetical benefit should count against him. And that's because the same reason I would have if you would say, well, if you're,
Well, when he got his subsequent lawyer, the lawyer continued on with the DNA on that DNA route?
Yes, his lawyer later did, yes.
Okay, so if he had gotten, if the motion had been acted upon and he had gotten a new lawyer within that, say after 30 days, they still would have been pursuing the defendant's request for DNA testing. And that would not have counted against the Commonwealth.
Maybe they would have, but that's hypothetical. We don't know that. And the thing that
he didn't abandon the DNA testing.
No, he didn't. But obviously, this lawyer wasn't successful in talking him into it. And the thing is that in all these
he wanted to go to trial.
Yes,
that's what he wanted. And I take it that what he wanted to do was pursue a DNA defense, but not if that delayed the trial. I mean, that's
correct. That was his clear instruction, right? He said, if the DNA, fine, but not if it delays the trial. I want to go forward. And he told Attorney Jordan at the end of, I think it was April, that he said, let's, I don't know how it could be raised in appeal, but let's save the DNA for appeal and just go straight to trial. He couldn't have made it any more clear. If he had, I guess he could have filed some other kind of motion, but he made it pretty clear. And even though all of those motions may not have been, maybe the court wouldn't be required to act on those motions since they were filed pro se and filed by a represented defendant, it was required to give him a hearing on that first motion on page A36. And that was clear. There's no way the clerk could have not understood it. It was written in plain English. It was on one of these forms they get at the prison. And the guy was incarcerated, and he wanted to go to trial. And that was it, and he made it very clear. So for those reasons, we would ask that the court dismiss the indictment, reverse the judgment, and I believe if that is done, also there's an issue of recalling the rescript that was issued by the appeals court.
Thank you, Ms. Sweeney.
Thank you.
Mr. Zanini?
Morning. Madam Chief Justice, Justices, John Zanini for the Commonwealth. I would recommend to the court, there's a transcript, there are various transcripts with the case. There's a transcript of May 8, 2003, which is the evidentiary hearing on the ultimate motion to dismiss under Rule 36, which was litigated. Attorney Jordan was called as a witness. There are two transcripts of the same date. One is Attorney Jordan, one is successor counsel, Attorney Murray. Attorney Jordan, the pages that I found most useful were pages 10 to 11, 45 to 60, and 108 to 112 of Attorney Jordan's testimony. And what Attorney Jordan describes is that when he arrives in court in June 25th of 2002, he has a discussion. His recollection is Judge King tells him, there are all these pro se motions, go speak with your client about all of these motions. And he does go and speak with his client. His recollection is on July 12th. And those motions include various discovery motions, as well as the motion to dismiss Attorney Jordan, as well as speedy trial motions. And after discussing this with his client, he returns to court. The docket indicates and the testimony indicates July 17th, at which time he asks that the court bring his client in for the next date.
For what, sorry, Mr.
For the next date,
oh, okay.
just to bring him in so that his client can have a discussion with the judge about all of these motions. On August 28th, the defendant is not brought in, and Attorney Jordan objects that day and says, I object to any continuance. He said he reads it into the record, his objection on that date. On September 9th, the defendant is brought in, and the defendant does speak personally with Judge McAvoy. And on September 9th, according to Attorney Jordan's testimony about that day, from Attorney Jordan did not say, he did not say to Judge McAvoy, remove me, replace me. I mean, he just sort of said, my client had a conversation with Judge McAvoy that day. I also, if you compare the docket with his testimony, he filed and had allowed an omnibus discovery motion, which seemed to consolidate all of the defendant's pro se discovery motions, and attended to that matter. The defendant, from all that appears of record, did not ask the attorney be removed and did not say on that day to the judge, get me a trial date right now. The matter is
And
then...
it's clear from the record that the defendant was in court that day?
Yes. That's the testimony of Attorney Jordan at the hearing, and that is reflected on the docket that's in the defendant's record appendix.
So we don't have any transcript of that? It's the testimony of the lawyer saying what he observed at this hearing?
Correct. There is
But was
no
the lawyer actually involved, or did the judge just speak to the client privately?
That is not clear in the first session. Typically, particularly in this case, the defendant would be in the dock, and the judge would be on the bench, and there would be a conversation in open court. The lawyer would be next to the client, but generally there would be no private conversation anywhere between the judge and the defendant in this circumstance.
But generally it would be on the record.
I take it the transcript to which you refer, that the May 8 transcript is here?
I assume it's filed with the court, and I will verify with the clerk if it's
Because, yeah.
If it's not, I'll
Would you do that? Thank you.
Was that refuted? Was that testimony refuted by the defendant?
It was not. He was not, to my reading of the transcript, he was not challenged on that on cross-examination by Attorney Courtney. The defendant did not personally testify at this hearing. He did not offer any evidence that that conversation did not occur, nor did he attempt to dispute that the omnibus discovery motion sort of was addressed by the court and allowed that date. That's on the docket. So things go back to a state of, more or less, things are okay. There is this tension that's always present in this case between pursuing the DNA test result and getting to trial as fast as possible.
So how do we deal with the time period from June 12th, when he files his motion to dismiss his attorney, and when he's finally brought into court on September 9th, 3 months later?
Well, I would suggest that from June 12th to August 28th, when the first objection is made, is all excludable. And the time from June 12th, there are...
And why would you say that?
Because there's no... The attorney is agreeing to continuances, and under Rule 36, if there's an attorney in the case...
Well, but I understand, but how can the attorney agree to continuances after the defendant has filed a motion to dismiss the attorney?
Because what the motion to dismiss the attorney triggers is a hearing on whether to dismiss the attorney. It does not trigger the clock under Rule 36 for includable time. And
not for want of trying, such a hearing didn't happen for 3 months, right?
Well...
I mean, he files a habeas corpus petition, he writes to the clerk, he writes to the Chief Justice of the Superior Court, he files a complaint with the BBO, he's still not brought in.
He's not brought it in until September 9th, but on August 28th is the day the objection is made. So I would suggest from June...
His lawyers finally decided maybe he ought to object, since his client has been trying to dismiss him for failing to object to these continuances.
Well, the motion to dismiss has a nice checklist on it, and the client essentially goes through and checks it all off. He wants to dismiss him for every possible reason that's on the checklist. That's my recollection of the checklist. Also, in the clerk's minutes, the motion is not, these motions, and there's about 5 motions that the defendant files pro se at this time. In the clerk's minutes, which is page appendix 79, they're all written down in the clerk's minutes on 6/21/02, and they're all numbered consecutively in there. So the clerk is, it's not like the clerk is hiding anything from anyone. It's not like they've segregated this off and put it aside and said, don't worry about the pro se motions, don't pay any attention to that, there's no one behind the curtain. Because what happens is that Judge King is clearly aware of it and says, according to the testimony of Attorney Jordan, they're in court 4 days later, And Attorney Jordan first becomes aware of these motions on June 25th, and Judge King says, please go speak to your client. And he goes and talks to his client on July 12th. And then the next date they're in court, he says, please bring my client in for the next date. But he clearly doesn't think that he's got a duty to withdraw at that point, a duty to move to withdraw. He doesn't think there's some sort of irreconcilable conflict. He's preparing an omnibus discovery motion, which he ultimately files and allows. And I think the proof is in the pudding. Once the defendant is brought in, and according to Attorney Jordan's testimony, the defendant speaks with Judge McAvoy. And after that, they go along for another month before there's a BBO complaint filed, when the defendant decides once again, well, I no longer want this lawyer.
I thought the BBO complaint was filed in August. Is that not the case?
My recollection of Attorney Jordan's testimony is that it may have been sent to the BBO sometime around August. He didn't learn about it till after that, and that once he learned of it from a letter from the BBO, that was the time when he moved to withdraw.
When this kind of a motion is filed, a motion to dismiss my attorney, what obligations does the Commonwealth have to make sure that that is brought to the attention of a judge?
I think the Commonwealth is in a very difficult position because we have an obligation not to interfere in any way with the relationship between attorney and client, and we have an obligation not to cast any aspersions that the defendant might learn of that would suggest to the defendant that the Commonwealth thinks his attorney is not doing everything the attorney ought to be doing. So I think here, where they're in court on June 25th and the judge says, please go talk to your client about all these motions, the Commonwealth probably was in court, probably heard that, and didn't have any obligation to do anything.
Mr. Zanini,
yes.
I asked Ms. Sweeney, and maybe you can answer this for me. When the judge indicated in his findings that the judge said the court concludes that if the defendant truly believed in June of 2002 that Attorney Jordan was not properly representing his interests and wishes, then the defendant should have pursued his motion to dismiss Attorney Jordan as he in fact later did with Attorney Jordan. What was the judge referring to when he talked about as he in fact later did?
I think that he was probably referring to the BBO complaint, which then prompted Attorney Jordan.
Your position is that when the defendant was brought in and spoke directly to the judge, if he had wanted to pursue it, he could have said right then and there, I want this lawyer removed as my attorney.
I think that's a fair statement.
Which he
Mr.
did not
Zanini,
do.
I know the issue, I don't think has been briefed, but we have in this Commonwealth unusually, we always think that a defendant has a right to counsel, which of course a defendant does in certain criminal cases, but there's also a constitutional right to represent yourself, which was what this Commonwealth, how it distinguished itself very much from the mother country where you could only be with. To what extent does that play in? Because I understand the problem that the Commonwealth has with, from my point of view, it's as if the Commonwealth got a motion from another attorney and started dealing with a second attorney. The Commonwealth couldn't possibly do that while the first attorney hadn't. I mean, you just couldn't do that. To what extent does it make any difference where you've got somebody trying to assert that he wants to get rid of his lawyer?
That might make a difference, but in this case it's not here, because if you look at appendix page 36,
Yeah.
he says, motion to dismiss appointed counsel and to appoint new counsel.
Okay.
It's both the caption
Okay.
and the very first sentence. And so that's what he wants, is he's had enough with Attorney Jordan, apparently on the day he sends that checklist in, although after that he's perfectly fine with Attorney Jordan on September 9th. And then Attorney Murray, when she testifies, Crystal Murray is appointed, she testifies, and there's a trial date for December 4th, which she got a continuance of in order to pursue the DNA testing. And then the defendant moves to replace her, and she said, well, it came as a surprise to me. He wasn't agreeing to continuances because we were pursuing DNA testing. He never told me not to. And everyone agreed from the beginning of the case till the end of the case that the DNA evidence, in the view of all of the lawyers, was absolutely critical. At the beginning of the case, Attorney Jordan testifies and says, gee, I was told at the outset by the prosecutor, if the DNA came back and did not include my client, then the case was in all likelihood going to go away. That would be the end of the case. because this is an acquaintance. He's had a relationship with the victim, the defendant, for a number of years. He goes back to see her after he gets out of prison. He allegedly rapes her. She doesn't report the rape for about 75 days when she has a miscarriage. There's a very small amount of fetal tissue, and there was a great deal of difficulty in getting the fetal tissue tested. You had to extract cells and replicate cells and do all of this difficult stuff. Dr. Bieber from Harvard got involved, and his efforts were unsuccessful, and finally Cellmark Orchid did get a test result at the request of the Commonwealth after the defendant had failed with Cellmark Orchid and Dr. Bieber to get a test result. It came back inconclusive. They got a test result in the middle of trial. And on the eve of trial, the Commonwealth was saying, if we can have another 2 weeks, we'll probably have a test result. And the judge said, it's been long enough, let's go to trial. And on the eve of trial, the prosecutor was again telling the judge, you know, if it doesn't match him, I'm going to go back and ask for a null pros, and that'll be the end of that. But they do go to trial. His defense, if you read his pro se pleadings, which are in the appendix, and his letters to the judge, he is saying alibi, I was at work, and I haven't seen her for 2 years. So clearly his attorney is pursuing the DNA test result, the exclusion, and the Commonwealth is recognizing that because that's going to be dispositive. If he's got his work alibi and his DNA is not there, that's the end of the case. It ultimately comes back, in fact, he's not excluded, so they continue on to the jury verdict. The jury acquits on the sexual assault charges, but does convict him of violating the restraining order. So they clearly believed he was present in contact with that woman that night. They just didn't find that it was non-consensual.
Was the DNA evidence available for trial and introduced in evidence?
It was introduced in evidence ultimately at trial. It arrived just, you know, sort of in the nick of time, and Cellmark got on and described the statistical odds of contributors, but he was included within the pool.
Was the defendant's DNA evidence also admitted?
That was the evidence. The defendant was trying to get it, couldn't get it. Ultimately, the Commonwealth got the whole tissue sample sent from Dr. Bieber to Cellmark Orchid. They did a different sort of extraction, got it. So that was everybody's DNA evidence.
Mr. Zanini, just for frame of reference, how long did it take from the time the defendant was indicted for this trial to take place?
It was just 900 plus days. There was a year of
the trial took place in 900 days?
Well, it was over 900. 900 and probably in the nature of 960 or 70 days.
And he was incarcerated, held on bail all that time?
He was not held on bail that entire time. There was a 360-day period from January of 01. For 360 days, he was committed as a result of a violation of probation on a prior sentence.
Okay.
And if you look at the docket, he doesn't file anything pro se from January of 01. He doesn't file anything pro se until October of 01. So when he's getting very close to his release date, he files his first pro se motion to dismiss. It's not even 1 year since the case was indicted, by the way. It's a premature motion. And then he proceeds to file in the springtime between March and June. He files a whole series of motions to dismiss, motion for speedy trial. He's got McCarthy and Odell attacks on the grand jury in there. He's got a motion to reduce bail.
Was he held in lieu of bail during any period?
No, he was on
He wasn't
probation.
able to post bail. So at the end, when they sentenced him, they took out the 360 days, sentenced him to 2.5 years for the violation of restraining order. 2 years they gave him 200 days to serve, so they sort of took all of his time and then put him on probation. He was not able to post bail.
Thank you, Mr. Zanini.
Thank you.